Yeah. He's on his way.
May I approach the podium now?
You may. Before we get started and before the defendant gets brought out, these two announcements he doesn't need to be present for. The state is present and so is the defense. The phone number did not go out over the air, just to assure everybody that Ms. Reeves' cell phone number did not go out over the air. I'd ask that the media that are present please refrain from publishing. I know you would do that, but I appreciate that. Second thing, just to make sure there's an announcement to keep this clear, the media can use their cell phones for purposes of recording today's proceedings, audio recording, not video, but audio recording. So if you are credentialed media and you've checked in with the public information officer, you can use your cell phones for the purposes of audio recordings. You can set up however you want. As soon as you find it, Brian will proceed. While we're waiting, we might as well use the time. Again, something that Mr. Reeves does not need to be present for and that you can inform him of. This is more directed to the victim's representative. For the record, Mr. Reeves is now being brought into the courtroom. Mr. Grimaldi, I know that I indicated earlier in the proceedings yesterday that your client was, of course, invited to make a statement if she wished, and she's entitled to do that at every state proceedings. I presume the state is going to tell me when you're ready to make your statement. One of the things you need to keep in mind is if you want to make the statement before the court rules on bond, if you want to do that, and it's in any way related to whether I should grant bond, she's subject to cross-examination by Mr. Escobar if he wishes to cross-examine her as to any aspect of whether bond should be granted. So it's just something that you should consider. She's, of course, free to make the statement, but I needed to make sure that she was informed that she would be subject to cross-examination. If it's related to the bond proceeding. So y'all let me know what you want to do, okay? All right. You ready to proceed, Mr. Escobar?
I am, Your Honor.
Okay. You may proceed.
Good morning, Detective Proctor.
Good morning, sir.
Detective, you were assigned in this case as being the lead detective in this matter?
Yes, sir, I was.
Okay, and how early were you assigned to that role?
10 or 15 minutes of being on scene.
Okay, and tell the court, if you can, just briefly, your role as the lead detective. What are your duties in a case like this?
To assure that the investigation is completed, people are interviewed, evidence is collected, submitted, things like that.
Okay, and so part of your duties there is to interview either yourself or through colleagues that are assisting you in this investigation, as many of the witnesses as humanly possible, correct?
That's correct.
And if you're not interviewing the witnesses, certainly what you want is those officers that are interviewing the witnesses to either provide you documentation or to explain to you what those witnesses are saying concerning the incident.
That's correct.
So that you can take all of these statements in and start trying to figure out what happened.
That's correct.
And that's just merely on an interview process, correct?
That's correct.
There's also a physical evidence process, correct?
That's correct.
And as part of your investigation of the physical evidence, you actually have a team of tech investigators that come in and they mark evidence, correct?
That's correct.
They don't disturb evidence,
That's
correct? And they photograph them, hopefully in their virgin state.
That's correct. And
the whole purpose of that is so at a later point in time, you can either have conversations with them or you can actually walk with them through the scene and you're able to see physical pieces of evidence that may be relevant to a case like this.
Yes, sir.
And it's crucial that the evidence not be disturbed because we can get all sorts of information from evidence, correct? Fingerprints, DNA, you name it.
Yes.
Fibers.
Yes, sir.
And so tell me how you made sure that the physical evidence in this case was not going to be disturbed and it was going to be preserved.
Judge, I'm going to object. This is outside the scope of direct examination.
Over.
Tell me how you did that.
I'm sorry, sir.
How did you do that?
Do what?
Make sure that the physical evidence was not going to be disturbed, and it was going to be preserved, and it was going to be collected properly and then submitted into evidence.
I have complete confidence in our team as far as their abilities to collect, preserve, maintain evidence.
Did you not have conversations with your investigative unit that came out to do that beforehand, before they started engaging in that process?
Sir, they're trained in that aspect. I did not have time to address that. They're already aware of their job.
Okay. You didn't even tell them a little bit about what the allegations were, or the facts were, so that they could, possibly look for evidence on their own from an intelligent perspective, a knowledgeable perspective.
Are you referring to forensic techs, sir?
Yes.
Forensic techs, I had very limited contact with them well into the investigation that afternoon. My main focus arriving on scene was I received a briefing from patrol deputies there on scene. The forensic techs are assigned. They know what to do. We had a detective there that's very competent, knows how to make sure everything's done properly.
Well, let me ask you a question. Before you even started doing your interviews, did you take an opportunity to walk into the scene of that theater?
No, sir.
And why not?
I didn't need to. I was advised of what occurred. I didn't need to actually see it at that time.
You didn't want to see for yourself where certain pieces of evidence were, so that when you went to go interview individuals, you could do that more competently?
I didn't feel the need to do that, sir. I was explained, I was given a good detail as to what occurred, where it occurred at. I did not go into the scene until after I conducted my interviews.
Okay.
I understand that the scene was, it was a crime scene there. We had deputies there monitoring. I've got people inside that are relaying information to me as to what's occurring, and I didn't feel the need to go in at that time.
Well, prior to even going to start doing these interviews that you were conducting, did anyone indicate to you what seats were occupied by number? What seats were occupied by Mr. and Mrs. Reeves?
No, sir.
Prior to going and doing interview, did anyone indicate to you what seats were occupied by Mr. and Mrs. Olson?
Are you referring, you said earlier by number.
Yeah, like counting from the right aisleway, 1, 2, 3, 4, 5, 6, 7. Did anyone give you any indication, listen, this is where Mr. Reeves and Mrs. Reeves were, and this is where Mr. Olson and Mrs. Olson were, before you started interviews? Yes or no?
Oh. They did not give me seat numbers. They told me that they were on the back, Mr. Reeves was on the back row.
Okay.
And that the victims were sitting in front of them.
Okay, well, did they tell you whether it was Mrs. Olson that was sitting directly in front of Mr. Reeves? Did they give you that information?
I don't recall at that time, sir, if I had that information.
You recall it now, though. You know what seat Mrs. Olson was occupying in row B, correct?
Row B?
Yeah, row B. Do you know what seat Mrs. Olson was occupying in row B?
Yes, sir.
Okay, what seat is that?
I don't know. I don't have it here in front of me.
Do you know how that seat relates to the seat that Mr. Reeves was in?
That seat would have been directly in front of Mr. Reeves.
Okay, so your understanding today is that Mrs. Reeves was sitting right directly in front of Mr. Reeves?
That's correct.
I think you mean Mrs. Olson.
Mrs. Olson.
I'm sorry.
We're both probably using the wrong name. You believe that Mrs. Olson was seated directly in front of Mr. Reeves' seat?
That's correct.
Mrs. Olson in row B, Mr. Reeves in row A.
That's correct.
And that row A is a row that backs up to a wall, correct?
Yes, sir.
And so today, your understanding then is that Mr. Olson was seated to the right of his wife.
That's my understanding, yes, sir.
Did you know that before you did the interviews?
I would object to this line of questioning being outside the scope of direct examination. My questions to Detective Proctor dealt with the interview of the defendant, and it also dealt with the interview of Mrs. Reeves. This is clearly beyond the scope of my direct examination. This isn't a discovery deposition. This does not go to any of the issues of the bond.
I agree with everything, so the last thing that you said, it may go to the issue of the bond, although I expect you to get there soon.
I would, Your Honor, but I would also tell the court that the affidavit, the arrest affidavit, is part of this particular case. We have an Arthur hearing. The court recalls part of the affidavit here was part of that original Arthur hearing that we got the right to re-litigate without prejudice back in first appearance. And so I'm also going to be going through the verbiage in this criminal report affidavit. I'll be more than glad to show it to the court.
I have a copy of the arrest affidavit, and I have reviewed it many times. Why is it necessary to go through the affidavit if not superseded by the testimony the court is having offered to it by the state for purposes of determining the pretrial detention?
Your Honor, I don't think so. I think that it goes hand in hand with his investigation and the evidence that was introduced at the previous hearing, and I have the right to confront that and to shed some light for this court so that as I made my arguments in my motion,
I read those also.
there wasn't PC at the time of the initial appearance, and there wasn't evidence that was, presumption grade proof evident.
Let's say that that was the case, hypothetically. What difference does that make today if the previous ruling may or may not, and I'm not ruling one way or another, but say the previous ruling was incorrect? What difference does that make today, given that I'm to rely on the testimony that I've heard at this hearing?
Well, Your Honor, he started off, obviously, this particular hearing by claiming that he was the investigator that investigated this case. That gives me the ability to actually examine him on that investigation, not just the fact that they decided to introduce 2 tapes in this particular case, because that's the basis of my evidence to show that the evidence that he put forth in the affidavit, the evidence that he's put forth here is not all the evidence. So at the very least, under the doctrine of completeness, I'm entitled to question his tactics in his investigation and other important information that he has that I can tell the court that I'm going to get out.
That'd probably be why I've overruled all of Mr. Garcia's objections, but that doesn't answer my question. Why does it matter what's written in the affidavit at this point? That was where we were going, and you veered off to something I've already sustained on your behalf.
Because that was introduced, Your Honor, in the initial hearing. That was ruled upon in the initial hearing, and I know you read my motion attacks that particular information as the basis for probable cause, and it attacks the basis of the degree of proof that the government is seeking here to hold my client without bond.
I understand, but I'm not an appellate body. I'm not ruling on what Judge Tepper ruled on, and what Judge Tepper ruled on is not binding on me. I'm pretty sure you don't want it to be binding on me. You want me to make an independent decision. To that end, my independent decision is based on what I hear today and last Wednesday. It's not based on what Judge Tepper did. So if Judge Tepper was incorrect, as you alleged in your motion, what difference does it make today? Why should I hear this because of that?
Because that evidence is already part of this case, Your Honor, and this court has every right to reconsider that evidence at any point in time, especially when Judge Tepper said, hey, I'm making this ruling without prejudice. Without prejudice for you all to revisit these particular issue in a full-blown hearing. And I provided the court a transcript of Judge Tepper's holding.
I have that, and I read it also.
And she said, you're right, we need a full-blown hearing on all these particular allegations. And so the affidavit is part of this case. And just because you don't sit in an appellate position doesn't mean that you can't review not only the testimony and the evidence that was presented at the initial appearance, but also throughout a bond hearing that we're also having at the same time. Because I've attacked the previous rulings as well as I'm asking this court to revisit the issue of bond and their standard of proof.
Well, let me make this clear for you and for the record. I'm not reviewing Judge Tepper's decision. Judge Tepper can reverse Judge Tepper. I can't reverse Judge Tepper. It's her decision, and her decision stands until I make my ruling. The way the rule is set up, I'm the only judge that's allowed to superimpose his judgment over her previous judgment, but it's not based on what she did. It's not based on what she said. It's not based on how she formed her ruling, and I'm not calling into question or affirming. I'm not doing any of that. I'm making an independent judgment based on the extensive testimony I heard on Wednesday, the extensive testimony I'm hearing today, those things that have been introduced in the form of exhibits, and that's it. I'm not making my judgment based on anything else. So if your purpose is to ask him whether the things that are written in the affidavit should, standing alone, constitute probable cause, for this to go forward, or probable cause for a second-degree murder, or any of the other things that you wrote in your motion. I'm not considering that. That's not my concern today. Solely what I heard on Wednesday, what I heard today, what I see in the form of evidence, that's it. So I'm going to let you keep going because I believe you're allowed to attack the foundation of the investigation in totality, although I expect that you're going to get to some point on this at some point, because as Mr. Garcia correctly pointed out, it's not a discovery deposition. It's not my intention to let you go 3 hours asking about every aspect of the case. That's not going to happen. So,
And Your Honor, I can tell you that I'm not. I've got pointed questions concerning particular issues that are of importance to us.
okay, then go proceed.
Now, with my last question, you certainly did not know prior to conducting your interviews as to where Mr. Olson was specifically sitting, correct?
He was sitting, and that's correct. I knew that he was sitting in front of Mr. Reeves.
Okay, but you didn't know exactly where?
No, sir.
Okay. Now, initially, you decided to conduct some interviews, and was one of the first interviews you conducted the interview with Mr. Reeves?
No, sir.
Okay. Who did you conduct first?
Corporal Hamilton and Miss Hamilton.
Okay. Let's take Miss Hamilton first. Now, Miss Hamilton's interview was conducted where?
At the movie theater.
Isn't it, was it in a closed room?
That's correct.
Now, Miss Hamilton told you that when Mr.
That is the hearsay.
Sustained. This is an impeachment. Sustained.
Now, your purpose of interviewing Miss Hamilton was what?
Gain information.
Okay. And gain information so that you could then ask Mr. Reeves relevant questions, correct?
To conduct the investigation, that's correct.
Okay. And so your second interview was Mr. Hamilton
No, sir. My first interview was Mr. Hamilton.
and then Mrs. Hamilton.
That's correct.
And then who was third?
Mr. Reeves.
Okay. We've heard the interview you had with Mr. Reeves, correct?
Yes, sir.
Okay. And we know that pretty early on, Mr. Reeves indicated to you that he had been struck in his face, correct?
Yes, sir, he did.
Okay. And he indicated to you not only that he had been struck in his face, but he indicated to you that he believed that the item that may have struck him in the face was a phone.
Yes, sir.
And so I would imagine then when you were going through that interview, one of your first topics was, I need to find that phone. Correct?
Yes, sir.
Because if he was struck with that phone, there could be some evidence on that phone, correct?
Yes, sir.
DNA,
Possibly.
fingerprints,
Possibly.
and you knew based upon your conversations with Mr. Hamilton as well as Mrs. Hamilton that Mr. Hamilton got to Mr. Reeves right away, correct?
Pretty quick, yes, sir.
And you were aware because of your interview with Mr. Hamilton, that Mr. Hamilton saw the phone right there in between Mr. Reeves' legs.
That's correct.
So prior to even going and interviewing Mr. Reeves, you knew that there was evidence right there where Mr. Reeves was sitting of this phone.
There was a phone there.
And you knew that it wasn't Mr. Reeves' phone.
That's correct, sir.
Mr. Reeves was cooperative with you.
To some degree, yes, sir.
He answered your questions to the best of his recollection.
Objection, Judge. Cause for speculation.
Sustained.
He answered your questions, correct?
He answered my questions.
And very early on in that questioning, he was complaining about his shoulder, correct?
That's correct.
And very early on in that particular interview, he was complaining about his face.
That's correct.
And I believe that and so one of the things that you wanted to do quite quickly was you wanted to take pictures of Mr. Reeves and his face, correct?
That's correct.
Did you do that, or did you have tech come over and assist you?
Forensic tech.
Okay. And did they do that in your presence?
No, sir.
Did you know what Mr. Reeves's face looked like before this incident? As far as marks, scratches, red marks, anything like that?
Not before the interview, no, sir.
You have in this exhibit, it's State's Exhibit number, looks like 3. You have a driver's license picture of Mr. Reeves.
Yes, sir.
Do you know when that was taken?
I don't recall, sir, without looking at it.
Would maybe me showing you this refresh your recollection?
Yes, sir.
May I approach, Your Honor?
You may.
Detective, I'm going to show you the prosecution's Exhibit 3.
The issue date of the license, according to this, is 8/26 of '09. It does not have the attached paperwork which would show the date of the picture.
Okay, so it shows the issue date of '09.
That's correct.
Okay. And do you know what changes have occurred between '09 and 2014 on Mr. Reeves' face?
Yes, sir, there's a picture here of him.
The picture of the date of January 13th, 2014.
The DL picture. Yes,
And
sir.
I'm talking about subsequent to that.
Okay, yes, sir.
That's the only thing you've got is the January 13th, 2014 picture, correct?
That's correct.
Okay. Now, in your conversations with Mr. Reeves, almost instantaneously, he told you, hey, my shoulder is killing me, correct?
Yes, sir.
He told you, I've been hit in the face, correct?
Yes, sir.
I'm 71 years old, correct?
Yes, sir.
I've got arthritis in both hands,
Yes, sir.
got a bad back,
Yes, sir.
I'm not very agile anymore, correct?
Yes, sir.
He complained to you or told you, explained to you his current physical condition at that time.
Yes, sir.
Does he look 71 years old to you?
No, sir.
You think he looks younger?
I do.
You do. What do you think makes Mr. Reeves to you look younger?
Looks to be in good health.
He does. Okay. So he tells you that he's there at the theater and the previews go on, correct?
Yes, sir. The CD, the taped interview explains all that. Yes, sir.
And he tells you that the lights were dimmed, correct?
That's correct.
And he tells you that the individual kind of catty-cornered to him, sitting beside Miss Olson, that individual was using a phone, and the screen to that phone had a light.
Yes, sir.
And he told you that, very politely, he said, sir, can you turn off that phone?
All right, as to the objection, here's what I'm going to tell you. There's a tape. Whatever's on the tape is whatever's on the tape. I love a good commit and confront cross-examination. And I don't want to give you any impression other than I think you do that fantastically. But if you're not getting to a point here soon, I see no reason for you to ask him exactly what we already heard, which is the best evidence. And I'm going to tell everybody, I told you till 6 o'clock. I'm holding my courtroom staff till 6 o'clock. If 6 o'clock comes, and because everybody's asked the same questions 3 times, we're not done, I'm not going to fret about it, but I'm not going to rush anybody, and I'm not going to go past 6 o'clock, because I've made a commitment to the courtroom staff that I will not. So, if you want to ask him everything that we just heard on that 29-minute tape again, I'm not seeing the value of it. You're good at your cross-examination, though, so that's why I've been letting it go, even though you've asked like 9 questions now. But I'm just telling you, 9 o'clock comes, or 6 o'clock comes, I'm not ruling on this, okay?
I understand.
Keep going.
Part of the reason for your interview is that you want to determine whether Mr. Reeves's actions are reasonable, correct?
That's correct.
And so he indicates to you that that first tap was, sir, can you turn your phone off? And he tells you that Mr. Olson said to him something to the effect of, fuck off or fuck you, right?
Judge, I'm going to object to this line of questioning. The best evidence in this case is the interview, which is in evidence.
Judge, they
Overruled. The reason that I'm going to overrule it and allow it to continue is Mr. Escobar is entitled to judge his or to get me to judge his investigation and completeness. I am presuming he's going to go someplace with this, because yesterday he went places with all of his cross-examination. I'm still hoping he's going to get there sooner.
Judge, if I may, his investigation is on an audio tape, which everyone in this courtroom has heard.
I heard it and I listened as closely as I could. Some of it was inaudible, so if he feels that he's got some portion of the inaudible part that he's going to be able to bring out through cross-examination, I'm going to allow it. Normally, you know that I would move somebody along, especially in a bond hearing. However, you're asking me today to make a finding of proof evident presumption great. And if I do that, that means that the man will be held without bond until trial, which in a second-degree murder oftentimes can go as long as 1 or 2 years down the road. So to that end, I'm taking every precaution to make sure that your interests are protected and Mr. Escobar, on behalf of his client's interests, are protected. I understand this is taking longer than anybody anticipated, but the sooner we let him get to it, the sooner we're through it.
I understand, Judge. But again, one other point. This is not a discovery deposition, and that is what this is turning into.
Now, it's a review of the evidence thus provided. I'm going to allow it to continue. Keep going, Mr. Escobar.
Now, Detective Proctor, he tells you then that when he is told those words of profanity in a very loud voice, correct?
I don't recall if he uses the word loud.
That he decides, I'm going to get up and I am going to go and speak to management, correct?
He did tell me he was going to go speak to management.
And that was something you wanted to evaluate because it's a reasonable, prudent thing for someone to do if they're having a problem in the theater, correct?
Mr. Escobar, it's not for him to decide what's reasonable and prudent to do. It's for me to decide whether it was reasonable and prudent. Do you have any other questions for him?
I do.
All right, continue with the questions you need to ask.
Did you verify that he went to speak to management?
I did.
He did, didn't he?
Yes, sir.
And then he comes back, he tells you, and the minute that he comes back and he sits down, he indicates to you that this individual turned around and was practically on his lap, correct?
There's a lot of things that are going on between that. During our conversation, his interview, he says additional things occur. I don't recall if he actually uses the terminology being in my lap, but he did give me the indication that he had turned around and in some way had threatened him.
And he described to you his tone of voice, Mr. Olson's tone of voice, correct?
I don't recall, sir, if that's on the tape or not.
He described to you the profanity that was taking place now.
He did describe the fact that he had used the F word.
He also described to you Mr. Olson's facial feature, correct?
Yes, sir, he did.
His aggressive posture, correct?
Yes, sir.
Those are all things that need to be considered when determining whether someone should use deadly force. Correct?
Judge, he's asking for a legal opinion now. I'm going to object.
Sustained.
And he reiterated multiple times about this phone hitting him in the face, correct?
I don't know how many times he had mentioned the phone, sir.
Now, following Mr. Reeves's interview, did you contact your investigative tech group so that they could tell you whether or not the positioning of that phone in reference to Mr. Reeves's chair?
Judge, I'm going to object to the relevancy of this line of questioning.
Overruled.
Did you call your techs?
Did I call my text?
Say text, hey, listen, tell me where, did you all find a phone? Where did you find it? Was it right between where Mr. Reeves was sitting.
That's, I wouldn't have called him. I would have made personal contact probably with Detective Smith.
Did you?
Yes.
And did she tell you, Detective, you're absolutely right, it was right there?
No.
What did she tell you?
The phone, there was a phone.
Judge, for the record, it's a he, it's Detective Aaron Smith, so the record is clear. It's not a she.
I haven't met her yet, Judge, I apologize.
It's him.
It's him.
Detective Aaron Smith, the gentleman that was just in running the audio.
I didn't
My
understand.
partner. Go ahead.
Did you talk to him?
Talk to who?
Mr. Smith?
Concerning?
That phone?
Yes.
Okay, and what did you ask him?
I asked him where the phone was at.
What did he tell you?
He said it was in the eye.
Object is to hearsay, Judge.
Overruled.
You asked him where in the eye?
No, sir.
Were you not wanting to corroborate Mr. Reeves' testimony to you that it was right in between his legs?
Judge, I'm going to object. It calls for speculation on the part of the
Sustained on that one.
I'm sorry, sir.
Mr. Reeves indicated to you that that phone was being used against him as a weapon, correct?
A weapon?
Yes, a weapon.
Judge, I'm going to object to the form of the question. Mr. Reeves in his interview says, I don't know what I got hit with. It could have been a fist, it could have been a phone, it was dark. I don't know.
Overruled, however, Mr. Escobar, I listened to the tape. I made notes, extensive notes of the tape. I'm going to rely to what I heard on the tape.
I understand.
Do you have any further questions for this detective that are relevant
do.
for this bond hearing?
I do.
Let's get to those.
Detective, on the issue of the phone, did you not want to corroborate Mr. Reeves' statement to you?
Judge, again,
Sustained. Ask a new question.
You also interviewed Mrs. Reeves, is that correct?
That's correct.
When you started your interview of Mrs. Reeves, was she upset?
Yes.
Was she crying?
To some degree, yes, sir.
Where did that interview take place?
Theater.
With the theater in a room or a theater in the open public?
No, sir. I believe they call it the party room.
So it was a room, just you and her alone?
Detective Myers is there.
Okay. She was visibly upset?
Yes, sir. Upset. Well, crying to some degree, yes.
Okay. And she indicated to you that during that episode with Mr. Olson, that she herself was in fear.
There again, that's on
Object to
tape.
mischaracterization. The audio-
Sustained. I'm going to rely on what I heard in the audio tape, unless you're asking if she said something to him off the audio tape. Is that what you're asking?
No, on the audio tape.
Then I will rely on what I heard on the audio tape.
Did she tell you that she turned away from Mr. Olson?
I don't recall her using that. I don't recall that. The tape stands, sir. I don't remember everything that she says on that tape.
When is the first time, Detective, that you actually viewed the telephone?
Objection is to the relevancy.
Overruled.
When's the first time you viewed the phone, Detective?
I went into the theater after I had conducted the interview with, after I conducted interviews.
And?
Give me a moment, sir.
Okay.
They were still in the process of collecting evidence. I do not recall seeing the phone up there at that time. Detective Smith was the crime scene detective. I had multiple forensic technicians in there, and I do not recall seeing the phone up there.
Now, early on in your investigation, you were aware, though, that there were cameras in that theater, correct?
Yes, sir.
When's the first time that you viewed the tape?
Several days later.
Several days later.
Yes, sir.
Were you not interested in determining whether that tape showed that phone coming at Mr. Reeves's face?
Would have been, yes, I would have been interested to see that, yes, sir.
So why didn't you view it that night?
Understand, sir, believe me, I wanted to view that video that night. Unfortunately, I didn't have control over that video. I didn't have that readily accessible to me. Given the opportunity, sir, I would have viewed that video before I interviewed Mr. Reeves. Unfortunately, I didn't have that ability. Cobb Theater.
Did you ask them to view the video?
Sure.
And what did they say?
They weren't able to do it. And I believe when you speak to Detective Smith, my partner, he can explain to you all those things concerning that.
So you said a couple of days later you viewed it for the first time?
Yes, sir.
Okay. How many times have you viewed that video?
30, 40 times.
And did you see that phone coming at Mr. Reeves's face?
No, sir.
You have, to this date, 24 days from the date of this incident, you have never seen the phone coming at Mr.
Mr.
Reeves.
Escobar, if you ask the question once and he tells you the answer and you don't like the answer, asking 2 and 3 more times is not going to help. I need you to just ask the question once. I'm trying to give you as much latitude as I can here, and I've shut the state down a lot, but I'm not going to let you ask him the same question 3 times. And that's what you were doing. You were asking it the second, and if I had let you, you would have asked it the third. But we're not going to do that, and I'm going to stop you if you do it again.
But I like that answer.
Okay, well, I'm glad you like that answer, but so, and just take it the first time, take yes for an answer, if it's the answer you like, okay? Let's go. What do you got next?
Did you have anyone, detective, try to play that video one frame at a time?
I'm not aware of the ability to be able to do that. We were not able to view it 1 frame at a time.
Did you ask anyone whether that was possible?
There again, Detective Smith, who's computer savvy, would have been able to have, I'm sure if he was able to do that, he would have provided that to me.
One more question with reference to the phone, and I think I'm completed with my cross of you. Did you ever go into evidence and pull that phone out of evidence?
Never.
Never. No further questions.
Mr.
Jan, if I could
Garcia?
have a quick
Oh.
second.
Yeah, forgot the magic words. May I have a moment to consult with counsel? That should be written at the top of everybody's pad.
I know.
All right. Mr. Michaels is giving you something. What do you give you?
He has it. Detective, oh, I'll pick that up right away. Detective, that phone, does the light on that phone turn on when you touch it?
I don't know.
Do you know what kind of phone it is?
I do not, without reviewing a proper receipt.
Okay, no further questions.
Okay. Mr. Garcia, do you need to ask any further questions of this witness?
Briefly, Judge. Detective Proctor, you had an opportunity to look at Mr. Reeves' driver's license photograph.
I did.
And does the driver's license photograph and the photograph that was taken on January 13th of 2014 to appear to be the same?
It's the same subject. He's lost some facial hair, maybe gained a few pounds.
Right, but when you compare the photographs, there's no injuries on Mr. Reeves on the side of his face, nothing that you saw.
That's correct.
And in fact, nothing that was captured on the photograph,
That's correct.
nothing further.
Okay. Thank you for coming in, Detective Proctor.
Thank you, sir.
All right, it is 11:54. Normally I'd go a little bit longer, but I have a feeling that the next witness is going to be a long-in-time witness also. Am I correct in that estimation, Mr. Gerson?
Judge, the next witness is going to be Detective Lindsay. He's probably going to be rather...
Short duration. Okay. All right, then let's do that.
Okay.
Okay. So Detective Lindsay, you're saying?
Yes, sir.
All right.
Judge, in the meantime, to move things along, I'm going to ask that the record reflect that I'm showing what's been marked as State's Exhibit J for identification purposes to Mr. Escobar.
And what is J?
Judge, it is the taped interview of Nicole Olson that was conducted by Detective Bill Lindsay at the hospital. It's our intention of playing it.
Okay.
Thank you.
Good morning, Detective Lindsay. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Come on up. You may proceed, Mr. Bishop.
Thank you, Your Honor. May it please the court, counsel. Detective Lindsay, good afternoon, sir.
Good afternoon.
Can you state your full legal name, please,
William Michael Lindsay,
and your profession?
detective with the Pasco County Sheriff's Office
And how long have you been employed with the Pasco County Sheriff's Office?
since 2000.
What are your duties with the Pasco County Sheriff's Office?
I'm a cybercrimes detective.
Did you have an occasion to assist in the investigation that occurred on January 13th of 2014 in reference to the homicide?
Yes, I did.
Did you have occasion to go to the hospital and interview Nicole Olson?
Yes, I did.
And did you record her interview?
Yes, I did.
Have you had an opportunity to listen to it?
Yes, I have.
Is it true and accurate?
Yes, sir.
Judge, at this time, I would move this into evidence as State's Exhibit number 5, I believe. And I would ask the court for permission to play it.
Are we five or six?
I'm sorry, 6.
Six, okay. Mr. Escobar, any objection?
No objection, no.
Without objection, you need to get to the
Please.
computer technician, I understand. Ready? Yeah.
It is January 13th, 2014. It's 16:05 hours. I'm with Nicole Olson at St. Joseph's Hospital in the emergency room. I'm going to be conducting an interview, reference case number, what's that case number, 14? Case number 14-1529. Okay. Just tell me everything that you can remember about what happened today.
Okay. My name's Nicole Olson. I went to the movies with my husband, Chad Olson. We went to see the Marine movie with Mark Wahlberg, Lone Survivor. And it started at 1:20, and we got there a little bit early. And my husband made small talk. Actually, the guy in front of us made some small talk with us, and we were getting ready to just watch the previews. The previews had just started, and the couple there was a couple behind us, a guy, and I assume a lady that he was sitting next to, and he got rude with my husband and just made some comments about turning off his cell phone. And my husband said, I definitely will in just a minute, but the previews, the previews are on. And my husband didn't turn around or anything, and the guy just kept, telling him, shut it off now. And so the guy said, do I need to go get a manager? And my husband said, you can do whatever you need to do. I'm just going to be a minute. I'm not talking. It was just the light on his cell phone that was on, no noise or